Hi there, my name is Ron Wright. I teach at the law school here at Wake Forest University, and today we're walking our way through the criminal process. We've reached the criminal trial, and trials are decided in the United States by juries. Judges and attorneys get to help pick who goes onto a jury, who can sit on a jury and who cannot. In particular, we're talking about a case today called Batson versus Kentucky, and it tells us that attorneys cannot use the race or gender of the juror as a basis for knocking them off that jury. So we'll be talking today about Batson Basics in picking a jury. Let's go in and talk. Okay, folks, let's get started. We're talking about the criminal trial now, and in particular, the jury. This is a distinctive feature of juries in the Anglo-American part of the legal world, sometimes known as the common law tradition. There's a whole different tradition in the civil law world, which we will talk about along the way, but juries are at the center of the criminal trial, both in England and then in the United States as an outgrowth of the English system. Why do we have juries? Well, Winston Churchill says it here in the slide, and I'm tempted to give you a really, really bad imitation of Winston Churchill, but that would be painful for all of us, so I'll just read what he has to say. He points out that this is a distinctively English and then American feature of the criminal trial, and it's a way of showing that the law flows from the people and is not given by the king. That is, this is the way for ordinary people to get involved in the enforcement of the criminal law. You become part of the judicial branch, the popular wing of the judicial branch, by serving on a jury. So that's what we're after. How do we get juries? How do we go about picking them? Well, it happens in two different stages. First of all, the clerk of the court calls people into the courthouse and says, Tuesday morning, it's your time to serve on the jury. So you call people into the venire. And then from that pool of jurors, then you pick a few of them to sit on the jury. So for that first step, getting people from out in the public to the pool, to the jury pool or the jury venire, we're usually asking about lists of voters, lists of all licensed drivers. You're trying to get a fair cross-section of the community to come in and be in the jury pool. And then in that second step, as you move from the pool of, let's say, 100 people to the 12 people plus 2 alternates who are going to serve on the jury, the way we do that is that, first of all, the judge knocks off some people for cause. I'll talk about that in a minute. And then the attorneys, both the prosecution and the defense, get to knock off a few people of their own. And so it's that those are the steps involved in picking a jury. The basic idea of calling people in and then excluding some people is that you believe that some jurors are going to be able to be fair and some jurors are just not going to be able to do their duty to listen to the evidence and give an impartial verdict. And so what you want is for the judge to knock off the people who are the most extremely pro-defense or pro-prosecution in their biases. And then the parties themselves can knock off people who might lean a little bit in one direction or another, so that you end up with a jury that everybody can live with. How do we know about these jurors? We don't know that much about each individual. We know something about their address and what they look like that day, and you might know something about their occupation, but you don't normally have a very deep biography of any of the people there as a way of predicting what they're going to do on the jury. There are certain civil cases where you hire consultants and they go out on the web and do all the research that they can because there's $1 billion riding on the case, but that's just typically not going to be true in a criminal trial. So what happens is the jurors come in, you don't know that much about them, and you just ask them a few questions. Sometimes these are called voir dire questions, to see, to say in Old French. So the voir dire questions, sometimes they're asked by the judge, sometimes the judge farms that out and lets the parties ask some of their own questions. And then based on those questions and answers from the pool of jurors and occasionally individual answers from individual jurors, then the judge decides whether to exclude somebody for cause, and after that the parties decide whether to knock somebody off using their own challenges. How does the judge go about deciding that? Well, usually there's some kind of law in the state court that will say to the judge, these are the kinds of things that you should treat as a ground for removal, a removal for cause. So under the Texas Code, for instance, the key item is that you remove a juror who has a bias or prejudice in favor of or against the defendant. So a biased juror. You know, the prosecutor's my cousin. The key witness for the defense is my next door neighbor. You know, something that makes you not able to be a fair juror, or perhaps I was a crime victim not so long ago, or some member of my family was a crime victim not so long ago. Something that would make the juror not able to listen to the evidence and give a fair verdict. Another interesting ground that the statute sometimes lists is if you've been convicted of a crime. In some states, that makes you ineligible to serve on a jury, or convicted at least of a felony, a serious crime, then you're not eligible to serve on a jury, at least under the Texas Code and under the statutes in some states. Think about the way that plays out in terms of which parts of the community are knocked out of the jury, particularly if you've got heavy drug enforcement in one part of the community and not in others, but a topic for a different day. So those are the removals for cause that the judge does. And then we move on to our topic for today, our main topic for today, which are the peremptory challenges. These are the challenges that the lawyers have. The prosecutor has some of them, the defense attorney has some of them. Typically they have an equal number. There are a few states that give the defense attorneys more than the prosecutor, more chances to knock people off, just to be extra fair. But in most states it's an equal number of challenges. Different numbers in different states. Somewhere between 12 and 20 would be a pretty normal number. Here in North Carolina, where I'm speaking to you, it's 6 for each side in a non-capital case. But each side gets to knock people off. And there's something interesting about the name, right? Peremptory challenge. That tells you something. It tells you that you don't have to have a reason. It can be for any unexplained reason. Does not admit of debate, question, and so forth from dictionary.com. Unexplained removals. I can just say, you know, I just don't like the vibe I'm getting from you and I can't put it into words. I'm going to knock you off. So that's the basic idea of a peremptory challenge. Unusual in the law that we say to somebody, you can make a decision in our legal proceedings that has no reason attached to it. You don't have to articulate it. Kind of weird in legal land to say words don't matter, but this is a setting where we say words don't matter. You don't need to put you don't have to attach a reason to your removal of a juror. But we say there are a couple of grounds that are off limits. You can have no reason at all. You can just knock somebody off because they seemed inattentive or because they just arched their eyebrow at you the wrong way when you walked in the door or whatever it is, but you can't use race, and then later we learn you can't use gender as a basis for removing a juror. Well, what does this do to the peremptory process? We've got an wonderful old clip from Clarence Darrow, one of the leading trial attorneys of the early 20th century, who describes in a magazine article for Esquire magazine in 1936, describes a strategy for removing jurors. And he goes through and he starts off saying, I'm a defense attorney, so the main thing I'm looking for is somebody who is a juror who is humane, somebody who can really appreciate human frailties and can have some forgiveness in their soul. And he says, but the court's going to do everything they can to prevent you from finding out if a juror is humane. They're going to limit the questions you can ask. So sometimes you've got to take shortcuts and just, go based on what you might know about their racial or ethnic background, just as a kind of shortcut or shorthand for what you really can't know in detail. So he says, Irishman, I love that. As a defense attorney, an Irishman is emotional, kindly, and sympathetic. I want that juror. Or an Englishman, well, he says, not as good as an Irishman, but still he's got a long tradition of individual rights and he's not afraid to stand alone. And he says, on the other hand, a German, as a defense attorney, I'm not so, a German's not so keen about individual rights except where they concern his own way of life. Liberty is not a theory, it's a way of living. So he says, Germans, no, not so much. Or a Presbyterian, he says, cold as the grave. He knows right from wrong, although he seldom finds anything right. So, and a wealthy man, he says, I don't want any wealthy men on my jury. Unless the defendant's accused of violating some kind of, white-collar crime, antitrust law, but any other kind of crime, no way. I don't want any wealthy men on my jury. So you can see the kind of shortcuts and, stereotypes, and frankly, racial stereotypes that sometimes traditionally have gone into the quick back-of-the-envelope thinking of attorneys as they pick a jury. So this process of a peremptory challenge has a long history of relying to some degree necessarily on stereotypes. But along comes the United States in 1986 in Batson versus Kentucky and says, we're not going to allow that. We're not going to allow race to be a basis for knocking out a juror. You can have no reason, but you can't use the wrong reason, and race is the wrong kind of reason. So we have a defendant who's on trial for burglary and receipt of stolen goods, not huge charges, smallish, lower level felonies, and it's an African-American defendant, and the prosecutor knocks out the first 4 African-American jurors who come into the box and just says, those are my peremptories. And the defendant says, wait a minute. This is racial discrimination. You can't knock out African-American jurors on the basis of their race. Now, the old legal test was a test under Swain versus Alabama, which said, okay, it's true that you can't use race, that's racial discrimination, but to prove that this is happening, you need to be able to see a pattern across many cases before you can make a case like this. Well, for the first time in Batson versus Kentucky, the court said, no, you don't need that proof across a lot of different cases. You can prove it based on what you see in one case. And what we see here is the first 4 African-American jurors into the box, knocked out by one party, by the prosecutor. So the court says, we've got this new test. It's a 3-part test. First of all, the prima facie case. If something happens in the pattern of the removal of jurors, for instance, the first 4 jurors of a particular race are removed by one party, the other party is allowed to stand up and say, hey, Batson motion, I think you're removing people based on their race. You didn't say so, but the pattern makes me think that's really what's going on. So one party stands up and raises the motion. Then the second stage in the process is the other party says, oh, no. It wasn't about race. I was not knocking them off because they were African Americans. I was knocking them off because those 4 people, along with some others, were, just seemed less enthused to be here. They were not so attentive, or maybe they were, scowling at me as I was speaking. It was their overall demeanor and their kind of enthusiasm about being here that made me knock them off the jury, not their race. And then the other party might say, the original moving party goes back to them, and this is the third stage. At this third stage, the moving party, the original party says, oh, come on, that's a complete fabrication. Look, there were lots of people who were scowling, who were inattentive, and you had no problem with the scowling white people. It was only the scowling black people that you knocked off of the jury. So they argue back and forth, and, with whatever they have to say, and then the judge has to decide, who do I believe? Do I believe that race was a motivating factor, or do I believe that that they were non-racial, neutral reasons that ultimately convinced this attorney to knock those people off the jury? If it's a racial reason, then the judge says that we're going to have to, there are various remedies for Batson violations, and we won't go into that today. But if it happens, we've got a violation of equal protection under the Constitution. So that's the legal test under Batson. We now know that Batson doesn't just apply to prosecutors. It applies to both prosecutors and defense attorneys. it doesn't apply just in criminal cases. It applies both in criminal cases and when we pick juries in civil cases, private party versus private party. We know that it applies not only if you're talking about African Americans, but if you're talking about Latinos or other race or ethnicity questions. We know that it applies to gender. If you're knocking off all the women or all the men from the jury, then that can lead to a Batson, an equal protection discrimination problem with the trial. And finally, the claim doesn't have to be raised by somebody of the excluded group. So if I'm a white defendant, but I think that black jurors would be very helpful to my case, they would be very sympathetic in listening to my case, and the prosecutor is knocking off all the African American jurors, then I can still object even if I'm a white defendant. So you don't have to be of the same, demographic group as the group being excluded. Anybody can raise these challenges. So Batson has become a sort of all-purpose anti-discrimination standard and a method of proving these claims that cuts across different parties, across different types of trials. Let's take a look at how this case applies and how hard it is to apply it sometimes. Our application case is from Georgia from 1993. It's called Lingo versus State. And we've got a case here where the prosecutor used all 10 peremptories and knocked off the first 10 black jurors who came into the box. And when asked under Batson, why did you do that? The prosecutor said, well, juror number 8 just seemed kind of touchy and hostile. And the other jurors, well, they were, a little worried about whether they would be able to take time away from their job. They seemed not to be especially wanting to be there. A dissenting judge or justice, Justice Sears Collins, says, I just don't believe that the trial judge did a very good job of evaluating the reasons that the parties gave. Ultimately, the trial judge listened to the parties and said, I believe the neutral, non-racial reasons that the prosecutor gave for removing these 10 jurors. And the Georgia Supreme Court affirmed that decision, said, okay, we'll go with whatever the trial court said. But the dissenting justice says, these reasons that the prosecutor gave were inconsistently applied. That is, when white jurors showed the same kind of behavior, it didn't seem to bother the prosecutor. It was only when black jurors showed that behavior. And there's an interesting category here, something called a proxy reason, where the prosecutor might say, well, I'm not knocking somebody off because of their race. Instead, I'm knocking them off because of their membership in a college fraternity that happens to have been one that is primarily with members of a racial minority. Or I'm knocking off people who like a certain form of music or listening to certain kinds of radio stations. There are certain kinds of reasons that become proxies for race, and so the courts sometimes will say that even though you're saying it's not race itself, it's something highly correlated with race, that amounts to the same thing. So at any rate, the court in Lingo, the majority of the Georgia Supreme Court, affirms the conviction and says, even though the prosecutor was 10 for 10, the prosecutor came up with reasons, gave reasons that the trial judge believed. We're not going to overturn the trial judge. That's a pretty common outcome in these cases. It's pretty common for the appellate courts to say, we're not going to overrule the trial judge because she was there or he was there, listening to the witnesses, could see the body language of the different speakers, could pick up on nuances. As an appellate court, it's all just written for us. We just see a transcript. We're going to miss too much, so we're going to normally defer to what the trial judge says. So this is now an inquiry, what was the real reason, that really rests mostly in the hands of trial judges. Does that mean that really what we need to do at the end of the day is just get rid of these peremptory challenges? Just ban them. Why should we let the parties privatize the selection of a public jury, of a jury in a public matter like a crime. And there are some people over the years who have argued for this, but I'll tell you, it's not practicing trial lawyers. Trial lawyers love their peremptory challenges. They vigorously fend off any arguments, any legislative proposals to restrict or get rid of peremptory challenges. It's one way that you can really, control your case. You can really make an impact for your client or for your case if you have something to say about knocking off the juror who's going to be really hostile to you. And the truth is, sometimes you walk in, there are 12 people in the box, and you can just tell there's something really not right about the connection you're trying to make with juror number 4 or juror number 7. You don't know why, but something's just off there, and you'd like to get rid of them and start fresh with somebody else who goes into that box number 7. So trial lawyers really value this trial technique, this ability to influence who's on the jury, and so as a practical matter, peremptories are not going away. Although at the end of the day, it is awfully hard to pick out when a party is using improper reasons, even under this Batson framework. So that covers the Batson framework for us and the difficulties of applying it as we get into the criminal trial.